Well, good afternoon. I'd like to say thanks for being here and welcome to our, this is the first time that this has happened since I've been at Grace Fellowship Church, an opportunity to get together and discuss some issues that are, well, they're multi-generational at this point. It doesn't really make any difference so long as you're in the workforce. These issues can affect and should be affecting you. So hopefully this will be informational for those of you that are here. Are you prepared for retirement? You know, or are you just coasting towards retirement? I thought I was prepared. So, you know, the last 3 or 4 years, I started preparing, but I was coasting before that. And then, you know, there was so much that I had to think about, so many decisions to have to make, that when it was all over, I thought, oh, I am so glad that's done. But then I started coasting. There are so many changes that go on in personal relationships that we value with one another, with our family, with our children. There are so many changes that go on that we need to continue to think about what we're doing. There are so many new laws that are put into place and I've only been retired for less than 10 years now, and there are so many new laws that are in place. So it's something that we really need to give focus to, not just before we retire or shortly after we retire, but while we are retired and on that process up to it. So kind of in keeping with that, we've invited Gwen Christensen, and she is an attorney from Jackson, estate planning. I'm going to have to read this. Let's see. She is a certified specialist estate planning, trust, and probate law. And she is from the Estate Planning Center down on Main Street. Gwen, have you been here for 22 years? 23 years in county, serving Amador County with what she does. She is a very, very great resource for everybody in our community and in our county. So Gwen will come and visit with us, and we also have Rhett Beal, who is a financial planner with Van Holzen Financial Services, and Nash Wiley, who is a advisor support associate with Van Holzen as well. Now, Van Holzen also serves directly in Jackson. They have an office over pretty close to the courthouse over there. Do I have the address? 711 Court Street. And so they are going to come and share their expertise with us and give you an opportunity for questions at the end of our get-together. And so, Gwen, would you come and share your heart with us?
Hi, everyone. I almost said good morning, but it's afternoon already. So thank you for being here on a beautiful Sunday afternoon, but we promise you're going to learn something today. And I am Gwen Christensen. I'm the owner of the Estate Planning Law Center. I opened my business here in Jackson when the old courthouse was up on Court Street. And I had a little office at 35 Court Street. My rent was $100 a month, and I was pregnant with my first son. So it was 23 years ago. But now I was fortunate. I bought a building in foreclosure, on Main Street, Jackson, in 2011, and we've been rebuilding it ever since. It's an old building from the 1930s. But if you come down to Jackson, you'll see my building. I'm right in between the radio station and the shoe store. But I've enjoyed having that Main Street location. I'm only 5 minutes from Amador Courthouse, and I do still go to court quite a bit. The probate calendar in Amador is pretty busy. We're going to talk today about why you need to have your decisions in writing and why you should have a will and trust in place. But sometimes people fail to put their documents in writing, and so we solve that problem. I'm a probate attorney, which means that I go to probate court, And so I do go to court from time to time to file probate petitions, which just means prove the will. We're looking to see this person has died and they have, do they have property? Do they have beneficiaries? We're actually putting everything in place for them. And sometimes I go to probate court because they have documents in writing, but they haven't been updated. And so there's an issue. There's an account left outside of the trust, or the person that was named as a trustee isn't a good choice. There's a number of things that we fight about in court. But I specialize only in estate planning. So when I opened that little court street office 23 years ago, I did a little bit of everything. I did a little bit of corporate law, a little bit of real estate law. But my first family law matter, the person died, and it became my first probate matter. And I never took another divorce case again. Those of you who have gone through a family law matter now know why. It gets really difficult when we're fighting about spousal support and child custody. And I have had a number of difficult probate matters, and I'll tell you a few stories today, or always in conversation. I like to give people some case examples. Some of the case examples make me a better drafting attorney, because when people say, for instance, oh, I want to have 3 co-trustees, I get to say, well, let me tell you about the 4-day trial I had when that wasn't a good idea. So I will talk a little bit about that today. Today, I wanted you to have some resources. So Wendy, who's here helping me today from my office, she's passed out to you the top 10 list. And this is one of my favorite resources. We have extra copies. It's also available on my website. So the Estate Planning Law Center can be shortened to TEPLC.com. And if you click on the website, you can click on archives, and then you can click on articles, and then you'll find this one. It's the top 10. And this is the top 10 things your survivor needs to know. And so today, with the help of Van Halsen Financial Management, they're going to be talking a lot about retirement and answering a lot of those questions. But what I want you to know about legacy planning is it does take a team of us. And so your financial advisor works with your attorney, who also works with your CPA or your enrolled agent. And so a lot of the financial questions, I'm going to defer those to them so that they can address those questions. I am here today as a resource to just make sure that you think about legacy planning, and that's where this top 10 is really going to help you define where are you in your legacy planning. So I hope you just choose one of the things here to focus on because it will help you decide what your next steps will be. And forgive me because I came without my watch and I'm already off time. So how are we doing on time? You're doing perfect. Okay, so I'll give myself 10 minutes from here. Okay, perfect. I can talk all afternoon, but some of you might have another meeting and dinner plans, I hear. So I'm going to go ahead and introduce to you the top 10 things your survivors need to know. And so the reason why this list is so important is that legacy planning, you have to be in the season of legacy planning. You can ask any of my children, they are all over 18, and they all signed a will on their 18th birthday. I'm sorry to say that. Actually, my daughter, Kate, she's the middle child. She avoided me for a whole week. She had a good excuse. She had a track meet on her birthday. But the reason why I made sure they signed their will, I also made sure they signed their power of attorney in healthcare. Because as their mother, I knew that if they became incapacitated after they were 18, I no longer had any legal authority as their guardian. And so it was very important to me because I do estates for a living, that they sign their power of attorney in healthcare, because those are your beginner documents. The reason why we call them beginner documents, or at least I do, is because you want to make sure that you have one in place, and as soon as you're 18, you can have a power of attorney in a healthcare document. The reason why you have two is one is just for finance, and one is for healthcare choices. And so here, the court, if I had not had that in place for my children and one of them became incapacitated, then I, as a parent, would be first in line to get court appointed as their conservator. But it was much easier if I just had them sign that power of attorney and healthcare document, and then my husband and I could help make decisions. And what happens with your power of attorney and healthcare document is you can change that as your circumstances change. And so for those of you who have documents up in place, take a look at the date you've signed them. The recommendation from my office is to have you double check them every 5 years. So here, I skipped ahead. I'm starting here with number 2, the location of estate plan. I started listing some of the documents that you're looking for. I have found over the years that sometimes people will pick up a healthcare directive at the doctor's office or the hospital, but they won't necessarily make sure they have a financial power of attorney document. Or they know they need a trust, and maybe they'll type one up or they'll find one on LegalZoom. But the recommendation is that you actually have an attorney help you with your estate plan, because, and you see by this list here that there's a number of documents that you need. And so the list here shows you, you do need a last will and testament, a healthcare directive, and a power of attorney. So those were the documents that I had my children sign when they turned 18. It's just the idea that the minute you're 18, you're an adult, and you can sign these legal documents. When we look at whether or not you need a trust, we're looking to see if you own real estate or if you have over $100,000. And so if that is your circumstance, you'll want to make sure that you meet with an attorney and make sure that you have a trust in place. And that's number 2, which is location of your estate plan. So I want you to think about where you're keeping your documents. There's a lot of people who they'll prepare their documents and they'll put them in a fireproof safe, or maybe they'll put them in a safe deposit box. My office at the Estate Planning Law Center, we do keep documents for people, but we keep copies of them. We keep electronic copy. When I first opened, I was keeping hard copies, but when I moved to Main Street, I decided I didn't want to take all those files with me, and we decided it was convenient and much easier if we scanned everything in. So we keep electronic copies, but you want to make sure that you have the official original document, and then you can also share copies with your children or with the people that you've named as trustee and executor. So that's number 3, location. The next thing I want to talk about is number 4, and that's the contact information for your legal heirs and beneficiaries. So I will tell you, when I first started over 20 years ago, we would have to hire a private investigator pretty frequently if the family had lost contact with certain individuals. I'm happy to report with internet, whether it's Facebook or LinkedIn, we are finding most relatives. Every once in a while, I have a case where the relatives don't know each other. I had one case in Sacramento that they ended up identifying 86 potential beneficiaries, and they were all cousins, and the cousins actually didn't really know each other. And every time my client called them to say, hello, I think you have an inheritance here, he got quite a few hang-ups. People weren't happy. They didn't know until the court paperwork started coming that there was actually an estate here that they would receive a portion of. And that wasn't a huge estate. There was about $300,000, but we still had the job of finding people that were related to this person. He died without any spouse. He died without any children or grandchildren, and the beneficiaries of his trust were his own parents who had predeceased him. So it was quite a task in court trying to find everyone on the family tree, because a lot of people had died, and if one person died leaving 5 children, and then those 5 children became the heirs of that child, and it just went on and on. So just a reason why we really like to have the contact information of who your legal heirs and beneficiaries are. What I want to tell you, the reason why I make that distinction is that a legal heir is a blood relative. You might not have someone named in your document as a beneficiary. So for example, if I have a client who's married and has 3 children, but maybe one child is from a previous marriage and maybe that child isn't part of the current estate plan, or sometimes we have a circumstance where someone is estranged and they're not a good choice, or there's no communication there. That legal heir still has to be noticed, even though they're not a beneficiary of the will and trust. And so my recommendation is for you to do the best you can. What we do in the office still is we hire a private investigator from time to time. But if we have a last known address, that's usually what the private investigator is looking for. And then we do have some people who will not share their addresses, but at least if we have a phone number, we can at least contact them. So that contact information is really important. The next thing I wanted to talk about is your contact information for your legal and financial team. And that's why I said before, it really does take a team effort because your estate plan is financial, it's legal, and then there's a lot of tax decisions that have to be made. So it's very important for you to know who's working for you right now, and then it's also very important for your trustee to know who is it that they're going to contact. And then number 6 is your funeral and burial instructions. It's okay if you haven't decided. That's another thing that should be on your legacy planning list. It's very helpful for your loved ones if they know whether or not you want to be cremated and whether or not you want to be buried. And our local provider, which is Daenerys Mortuary, they will do a consultation for you, just like my office will do a consultation for you. And so I always have to recommend to my clients that's something that should be on the list. If you do not decide, it is your healthcare agent who's going to decide for you. So for example, I'm married, I've got 3 kids. My son Connor knows he's first. It's not because he just finished his first year of law school. It's because he's the oldest child. Of course, my husband's first, but if we look at the children, this is why we want to have an estate plan in place, because I have a son and then 2 daughters. And so if I didn't have it in writing that my son was first, then my daughter Kate, then my daughter Bryn, it would look like they were fighting in court, because they would each have to file a petition saying, I'm a child and I'm willing to help, and I'm willing to make a financial or healthcare decision. And so that's why it's so important to have those decisions in place, especially with the healthcare directive, because if I have left a decision, sometimes people pre-plan and prepay. My son doesn't have to argue with his sisters about what did mom want? What did she say she wanted? Did she ever talk about it? It's actually in the file already what decision I've made about that. The next thing I want you to consider, and you'll see it here as number 7, this is decisions regarding your donation of organs. So any of you who have a donor sticker on your driver's license, make sure that your healthcare directive reflects the additional decisions you have to make. At least your healthcare directive allows you to communicate whether or not you want to donate, which organs you want to donate and for what purpose. And so that's very helpful information if you're an organ donor. A lot of my clients here locally in Jackson or even in Calaveras County, they will have already donated their body to UC Davis. And so if you have donated your body to UC Davis, that's very important information for your healthcare directive and agent to know. The next thing on my top 10 list here is number 8, which is specific gifts. And I will tell you, it seems like no big deal, but I have had the biggest cases in court about these specific gifts, even if it's something of nominal value. My favorite, and I actually share this with people not at church. I tell them we had a big fight over a Bible that was 99 years old, and I got a court order that the beneficiaries had to go home and look for it. They had 1 week. They weren't going to be able to cash their checks yet, and it's because we had testimony that the person that died was doing ancestry, and so someone who owned the family Bible FedExed it, called the person and said, "Do you have the Bible?" "Yes, I have the Bible." And then she died within days. And then whoever got to the house first took a few things home, which included the Bible. And we found out later it was for sale on eBay for $99. But luckily, had I not had that testimony, we had the FedEx receipt, We had the person who owned the Bible saying, I called her, she received the Bible. The courts would have told me, Gwen, too bad, we can't find this Bible. But it was very important for the estate to get this Bible back to the person that it belonged to. And so specific gifts, the other big fights I see the most is for blended families. When we have his and her property and his and her children, that's when we see the most fights. And so my recommendation, whether you have a blended family or just a family that shares the same children, you still want to do a gift list, because all the things in your house that have value, they can fight over. And when you leave a list that says who gets the jewelry or who gets the artwork or who gets the firearms, they don't have to appraise those items and split those items. For example, for me, I have 3 children, and they wouldn't have to split an item 3 ways. They would know exactly who is receiving that piece of jewelry or that piece of artwork. So I'm definitely going to recommend that you add that. That's something that you can create on your own. Number 9 is the asset list and the liability list. That is something that your trustee and executor has to do for you. But if you keep that information organized, they can do some detective work. They can take a look at your accounts and what bills you've paid recently, but it's very helpful for them if you have contact information for them for your mortgage company, or contact information for where you have credit cards or other monthly bills. So definitely keep that updated. And then number 10 might not apply to a lot of people in this room, but it's one of my favorites. It's business succession plan. And here in the foothills, I have a lot of families who run wineries or ranches or even law centers. Whatever the business might be, if you are running a business, you need to make sure that you know who's going to run it upon your incapacity or upon your death. And so business succession plans range depending on the type of the business it is, but it's also on the top 10 list. And so before I run out of time here, I want to go back to number 1, which is my favorite thing to talk about now. Legacy Love Letters is a book that just came out in December. And I have copies for you at the back if you'd like to pick up a paperback copy or hardback copy today. And the reason why I wrote this book, it's because this used to be on my top 10 list as number 7. And then I had a client write a love letter to his wife, and it's there in the last few pages of the book as an example. And I found out what a big impact it had on her to have this letter from her husband. It helped her with her grief. And I want you to know that when I first wrote this book, the first version of it was very legal, just like this one, a checklist, all the things you should do. Even the very first version of the checklist, it just write a letter to your loved one. But the reason why the book has had such an impact is that now I'm teaching people to write goodbye, I love you letters. And so even my clients who don't believe in God and don't believe in heaven, they still want to say goodbye to their loved ones. But my clients who do believe in God and do believe in heaven, they want to remind their loved ones that this is just a temporary farewell, that they're going to see them again in heaven. And so I've really been enjoying studying that and writing about it and sharing that with my clients and engagements like this one, coming to the church and speaking about it. You'll find in the book that in addition to love, I identified 7 ingredients. I found that as people expressed their love, they also needed to express forgiveness. Sometimes they were expressing sympathy or encouragement or hope or faith. And so if you're interested in that, I hope you pick up a copy of the book today, or we also have it available at my office, and we also have it available on Amazon or even Target.com and Walmart.com. And it's another thing that it's one of those things that not everyone just decides on a Sunday afternoon that they want to write a love letter, but it's part of your legacy plan. It is important to say goodbye to people. It's important to give them your final thoughts. What happens with legacy, and you'll hear about that today, with the financial of what a big impact you can make, whether it's charitable giving or providing for your loved ones. And so we all want to have a legacy with an impact. But as Christians, we also want to have a legacy that glorifies God. And so I really hope you take a look at that today. So my time is up. You guys ready? Thank you.
Thank you, Gwen. The two young men that are here now are from the Van Holzen Financial over off Court Street. Rhett he's a financial advisor and chartered special needs advisor. First time I read that, I thought, special needs in education, but I'm a teacher, so I don't think that's what it means. He grew up in Northern California in the foothills. Just found out he went to college, undergraduate college in Point Loma. He doesn't surf. I don't know what he was doing at Point Loma, but he went to Point Loma. He did play basketball for them down there. He was on their team, an experience that shaped his discipline and team-oriented approach in serving his clients. Along with him today is Nash Wiley. Nash is an advisor support associate with Van Holzen, and he focuses on trading and building financial plans to support client goals, is what he does. Nash is also a homegrown foothills type guy, went to Amador High School, spent his collegiate career playing football up at George Fox University just south of Portland, Newberg, Oregon. And captain of the football team up there actually helped shape his idea of what teamwork, especially in the financial area, really does mean. He's working now to become fully licensed so that he can serve his clients directly. So, Rhett, Nash, come on up.
Is this able to tilt? This will have to go up a little bit. Yes, definitely not surfing, much more into the outdoors, backpacking, hunting, horses, all that type of stuff. But had a great time down there. Gwen, that was awesome. Thank you so much. Particularly love the love letter. There's not much better than that. And one of the things I love about it is when you think of a love letter, it's not just what you're writing down, but things you're thinking about intentionally as setting in motion, right? Because some of the best legacies we leave behind is what we start setting in motion today. So my understanding of my role is really on the topic of giving, less on the retirement planning, but how do we give effectively? And I think I'm going to take this a little different approach than maybe you've heard it in the past, because anytime I hear giving, the most common thing that comes is, how do I save money on taxes? Or, hey, my CPA told me I need to give because I have paying too much in taxes. And really, if you think about it, even if we have a 30% tax rate, if I give $1 and I get a 30% tax break, I'm still out 70 cents. So at the end of the day, it would have been better to keep the dollar. So the intent of giving is not for the tax break. The intent of giving is in order to bless something good, right? To support some organization, and then we want to take advantage of tax breaks so that dollar can go further. A completely different perspective. But I'll be getting into that. And I also want to get into kind of this idea of giving within the Bible. Through my journey and my own experience, I am a financial advisor. And I started as a financial advisor right out of college in 2012. And going in through my 20s, I really actually was having a difficult time. I was doing Young Life, which is a high school ministry. And my wife and I were serving in various different ways. But I was really struggling with this idea of, where's my ministry and my work? I feel like I'm just managing money for rich people. Where does my ministry exist in this place when there's a lot more people in need and there's other financial advisors that exist that they could go to? It was a really deep question. And so about 5 to 8 years in, I was struggling and wrestling with this over and over again. And of course, the last place I looked was diving into the Bible. Human nature. But one of the things that I learned through finally diving into the Bible is, can anyone guess how many times it talks about faith and prayer in the Bible? Any guesses? Huh? About 500 each. So about 500 times it talks about prayer, and about 500 times it talks about faith. Could anyone take a guess how often it talks about money and resources? Any guesses? Over 2,000. Someone puts it out there at 2,350. Others put it just right above 2,000. It is one of the most talked about subjects in the entire Bible. And it really blew me back. Like, whoa, why is it so important? Because anytime we know we're reading passages, when they bring something up over and over and over again, it's really impactful. And through kind of the summary of what I learned is it's not how much you have, it's the relationship you have with it. It's not how much you have, it's the relationship you have with God, with people, and God's creation. And money is one of those things in God's creation. And I want to give a few real short summaries of Bible stories to really reflect kind of the both sides of the money equation, where some people are being blessed with a bunch and other people are being told to give it away. Right? We'll start with the first one, is where the story of the talents, right? One individual got 5 talents, another got 2, and the last one got 1 talent, or money. The one with 5 went and doubled it and turned it into 10. The one with 2 doubled it, turned it into 4. The one with 1 was nervous and buried it. And then when the master came back, said, hey, what did you do with my money? The one with 5 said, I doubled it. Same with the one with 2. And the one with 1 said, I buried it and I hid it, and here it is. I'm giving it back to you. And what happened? They took the individual that buried it, took the money away from him, and gave it to the one with 10, and made the one with 10 even wealthier. Kind of crazy. Then you get the opposite, the rich man. Rich young man comes to Jesus, says, hey, what is it to obtain salvation? And Jesus says, follow the laws. And he kind of comes back proud, like, I've done all that. What's he say back? Okay, give away all your money to the poor, the needy. And what happened to the rich young man? He walked away with his tail tucked. And then Jesus finally said, it's easier for a camel to go through an eye of a needle than a rich man to make it to heaven. 2 exact opposite stories. The prayer of Jabez, right? Lord, please expand my territory. But the key phrase is, before he said expand my territory, is in the work you've set out for me to do. And then God blessed him with many things. There's another moment, right, where Jesus kind of has this contrast where he says, those who try to save their life in this world will lose it. Those who give their life for my sake will get it. Whoa. What is that talking about? Material possessions? Thinking about us here in the U.S., that absolutely can be a story about money, wealth, fame, popularity. And the last one, where your treasure is, there your heart will also be. A lot of stories that go back and forth on this. And so I want to repeat the summary. What's it all about? Is about how much you have. It has nothing to do with how much you have. It has to do with where your heart is. It has to do with your priorities. And that's so very important because we have a problem here in the U.S. And this is very different than what's taught in the traditional financial planning and financial advising, and really what's taught out to us culturally, because we don't have many problems in the U.S., do we? Right, there's many. But one of the key things that we see is money has a major hold on us. It is one of the very first things we see and judge an individual for. And even if you're like, oh, you see that person? Look at the kind of car they got. Look kind of the house they got. Right? Look at the success they've had. Look at the business they've founded. It is the thing that we measure ourselves against, and it comes down into a productivity measurement, when really that's not what God wanted it for. Because God's kingdom of what storing your treasure or investing your treasures in heaven looks vastly different. So how do you reconcile this as a financial advisor that manages people with money, right? How do we reconcile this within the legacy concept? Because there is a solution for it. And what you'll find out is I am the ultimate optimist. I do believe there's a lot of challenges going on here locally. I do believe there's a lot of challenges going on in our nation and obviously the globe. But I also believe it is the opportunity for Christians to shine their light. Literally, it's sitting for us on the platter. If we see it and set these legacy instances and what's passionate on our heart and really show people our priorities and where our heart is, God first, then our spouse, then our children, and all other things, we have a way of changing our family. We have a way of changing our own lives and the community around us. And what I really like diving in on is, where are you investing your 3 T's? Your time, your treasure, and your talents. And I bring up the 3 T's because one of the most challenging subjects to talk about is giving. And pastors always hate talking about giving because it feels like give me money, and when they're paid through being a pastor. So it becomes a really challenging subject to talk about. But really what we want to talk about when it comes to giving in time, treasure, and talents is, in an era where we feel like giving fatigue, you go to Starbucks, McDonald's, every place asks for money now, and do you want to donate towards this? Do you want to donate towards that? The challenge is we're not connected with it, right? Giving fatigue stops when you are invested in it. And when you are invested in things that God has a passion for and has ordained in your life, you will now feel the freedom and the joy of giving. And when you find those things and you're investing in it with your time, treasure, and talents, you will see the reward, which there's also a book called The Giving Paradox, or The Paradox of Giving, and it talks about the people that give in this way actually have a much higher satisfaction rate in their life, feel much closer with God, and also get to see all the things that God's doing in and around our community. Because when we don't invest in that way, it's when we're missing all the things that God is actually doing to show that he's active. So I'm not going to have time to obviously get into the time and talents aspect because you guys want me to talk about the treasure aspect. How do we give in a way that is really structurally most advantageous? And how do we align that with what's most valuable to us? And one of the things that we need to talk about when it comes to giving is each and every one of us generally, naturally, are one of 2 things: spenders or savers. Right? If we're a spender, we can't wait to spend it on the next thing that we're excited about. And if we're a saver, we can't wait to see our bank account get a little bit bigger. I'm naturally a saver. Right? That's just how I'm naturally ingrained. It's how it was when I was just a little kid. And so what I had to do is I had to put principles in place to turn myself out of a saver and into a steward. So we want to switch from being either a spender and a saver and become a steward, because that's who God wants us to be. And I'll share a little bit how my wife and I do that, and then how we do that through a tax component, and I'll show various ways to do it tax-wise. One, as a saver, one of the hardest things to do is when you see your bank account get to a certain level, and then someone says, hey, give money, it's 3 times more impactful to lose something that you've never had than it was to have never had it at all. So what do? My wife and I have a separate bank account that every time we get a check in, we have an automatic transfer that goes to that bank account. And that money in that bank account is not seen as ours. Ever. Right? And you got to think of your own way. Right? That's just how we do it. And because we have a separate bank account that's always growing with the next check, the beautiful thing is it's no longer feeling like I'm taking something away that I once had. And my wife and I see it grow. And now we're looking for the opportunities to say, who can we give to? Who can we bless? Who can we support? My wife's a teacher. Sometimes it's just a kid needs a backpack, right? Sometimes it's getting kids to camp. I know you got a fun camp coming up here soon. Sometimes there's a disaster relief. We live in a fire zone. Often it's a church. Some organization, mission, things you're doing, but when it's there and available and it's growing, it teaches you to be aware, to be on the lookout for the things that are available so that you can be the first one to bless it without even having to think about it. So think about it for your life. What is the structure of your finances? Some of you may be retired, some of you may still be earning. Each person has a way to do this where now it feels like it's becoming a blessing rather than fatigue and, man, what am I going to miss out on? And it becomes really rewarding. And that'll also help you become a steward. The next thing that my wife and I plan to do, we got a 1- and 3-year-old. We want to invite our family members in on this. Kind of like the love letter. The important thing is all of us, I'm confident all of us care about our families a lot. And all of our families are complex and dynamic and have different passions. But there's ways to invite your family into this giving component so that you can reflect Jesus' heart, and through reflection of Jesus' heart, they can see your heart. There are a bunch of ways to do that through the time and talents, right? Inviting them along or going along with things that they're passionate about, but it's also you can do it with your money. And you don't even have to tell them how much money you're giving. You can put it in percentages. I'm just going to use round numbers. Let's say you have $1,000 you want to give. Invite your grandkids or your kids to that giving discussion. Hey, I have some money. If you're comfortable to say $1,000, do. Maybe it's $10,000. Maybe it's $100. Doesn't matter. You can also put it in a percentage. Hey, I have some money here. I want to give it to some organizations that you're really passionate about. Can you come alongside and let's give towards that organization, and then let's also do a serve day with that organization. That is starting to reflect what stewardship is like and starting to put legacies in motion, which is really a continuation of legacies of what Jesus has set in place thousands of years ago, right? And now you're able to bless the community. You're bringing your family along with it. And as you write these legacy love letters, they'll be able to reflect on their time of what was important and what's really important from putting God first. Then, getting into the more technical stuff, you should have a sheet of paper that kind of looks like this. Because I know I said we don't give to have tax write-off, but it doesn't mean when I give, I'm not going to take advantage of a tax write-off. So, a bunch of different ways to give, and it really depends on what you're giving and how much you're trying to give. And what I mean by what you're giving, is it cash? Is it appreciated stock? Is it a real estate investment? Is it a business? Because depending on what you're giving, there's a different strategic method to give out towards that's most tax advantageous and also best for the organization you're giving to. From a cash perspective, I'm assuming most of you have probably experienced that, given it directly, and you can get a tax write-off. So I'm going to talk about the more alternative ways that you can give outside of just typical cash. So at the very top, and I'm not going to get into all the bullet points specifically, as I know we kind of have a time thing, you'll see Nash has, if you guys want to get really technical, like, hey, what are the best ways to do this? How do I implement this into the family and have deeper conversations on that? That's really diving in, hey, tell me more about your family situation and ways to potentially approach it. Nash will have a little sign-up sheet, and then we can just do a phone call. I'm not going to try and sell you anything. It's just, hey, want to listen and want to be able to help you. Because the better I can help you, I know the better that the kingdom really gets to be shown. And we need a lot more of that. But some other tactical ways. Has anyone heard of a donor-advised fund, which is the second thing on that list? A donor-advised fund. Okay. So a donor-advised fund. Many organizations, such as if you got money held at Fidelity or Charles Schwab or Vanguard or many of the others, they have something that you can put money into called a donor-advised fund. And the awesome thing about a donor-advised fund is you can donate, or gift, I should say, gift money into this fund, whether it be cash, appreciated stock, or a real estate investment, really just about any type of investment. You get the tax write-off at that moment of the gift, at whatever value it was the day of that gift. And then you don't have to give it out to any organization at that time. So let's just say you have a larger gift of $20,000 you want to give, but you still don't know exactly who you want to give it to. You can put that $20,000 in that donor-advised fund today. You can have it earning interest so it keeps up with inflation. And then throughout the year or the next year or even the next year beyond that, you can gift the money out of that account at any time you want, as long as it's a qualified charitable organization. So what you can't do is like, oh, I want to take that out and now give it to help someone buy backpacks. It would have to go to a 501c organization, and you can have out of the donor advised fund, they'd send a check directly to them. And it doesn't have to be in the full amount. Let's say you have $20,000 in there and you want to give $2,000 to one and $1,000 to another. You can sparse it out however you want, but you can take advantage of that gift today. So really, the most common use of it is with appreciated stock. So if you're like a long-time holder of Apple, phenomenal resource to be able to put it in there at that time. So fantastic use of it, and also very flexible. Any questions on that? Okay. Who is taking RMDs? Required minimum distributions. There's a few. Okay. So As you all know, some of you say, hey, I need the RMD. Some of you may not. I don't know what your cash flow situation is like. But as soon as you are older than 70 and a half years old, you can gift the money out of your IRA. And I want to tell you what the advantage of gifting money out of your IRA is versus just gifting money out of your bank account. So let's say you put money into a 401k or an IRA on a pre-tax basis, right? You didn't pay any taxes when you put it into that account. It grew, accumulated tax-free over 30, 40, 50 years. You can gift the money out of that IRA directly to a charity, and it will never be taxed ever. All the tax write-offs are on all the accumulated gain, compound interest will be included in the gift. It counts and satisfies your RMD, and that money will never show up on your tax return. Doesn't matter if you're itemized deduction or a standard deduction. Pretty incredible. So think about it. If you are doing RMDs, instead of pulling the money out of the IRA and then paying the taxes and then giving a check to a church or something else, do it directly out of the IRA. It'll be far more tax advantageous because you'll never have that money hit your tax return in the first place. So that's called a qualified charitable distribution from an IRA. A charitable remainder trust. Has anyone heard of a charitable remainder trust? Yeah, as an attorney. Do you draft any charitable remainder trusts? Okay, perfect. So if anyone's interested in this, you talk to Gwen. So charitable remainder trust is a fantastic tool. This really comes into play, you can do it with appreciated stock, but really comes into play when people are looking to sell businesses most commonly, or have a major appreciated asset. Say you had a piece of asset like a real estate in the Bay Area. And if you do not need, let's just say you want to sell it and you need the cash flow off that asset still during your lifetime, but you want to gift it at the end of your life, a charitable remainder trust is a great solution. Let's just say you have $1 million asset, and its cost basis is $200,000. So you would traditionally pay taxes on $800,000 gain, keeping that very simplistic. Well, that would eat up into a lot of things. At the end of the day, you might have only $600,000 coming back to you to earn interest, dividends, and interest off of it. If you contributed that to a charitable remainder trust, it would not be taxed at all. You can gift all $1 million to it. You can invest all $1 million from it and generate dividends and interest, and that can be paid out to you during your lifetime so that you can live off of that money while still not needing to manage the real estate property or the business or anything else. But that the key thing that you need to know is at the end of your life, it would then be gifted to a charity that was chosen at the onset of that trust. So it would be an asset that you're saying, hey, this set of money, I don't need to go to my kids. My kids are doing okay. I don't want to manage this asset anymore, but I still want to generate the income off of the full amount, and you want to be charitable. A charitable remainder trust is a great resource to do that. If you're interested, call Gwen, call myself. It's a fantastic tool. I'm blanking on the name of the tool, the reverse of the charitable remainder trust. Then there's something called a charitable lead trust, which is essentially the exact opposite. You gift it, no taxes, but instead of you getting dividends and interest off of it during your lifetime, the dividends and interest go to a nonprofit charity during your lifetime, and then when you get called home to heaven, the asset then goes to your beneficiaries. Similar concept, exact opposite. So there are a lot of really neat tools and ways to do this where you can bless other people and also bring your family into these conversations. And then if you're yet to be, and let's just say something about appreciated assets, because some of you may have that. One of the things to know about appreciated assets, the great thing about gifting that is, let's just say you have Apple shares like I used beginning. If you had put $10,000 into Apple and it's worth $100,000 today, the great thing about the charitable gift, if you give that stock directly to a donor-advised fund or to a church or some organization directly, you get to write off that full $100,000, including your $10,000 original investment. So all this to know, there's a lot of different ways to give, and one of the things that I hope you guys have a takeaway on is the heart behind the giving, right? because each and every one of us, as Christians, should be optimists. God's already won the battle. There's a lot of things going on, but this is our way to really shine the light. And it doesn't just have to be with cash, doesn't just have to be with money, but the things that you invest your time, your treasure, and your talents, and really invest alongside God with that, it will remove the fatigue and really bring energy and allow your family to see what's really important to you. And that is the legacy that you set in motion, and then you can share through that love letter. Thanks so much. Oh, any questions that I should have that people have? Should have started that. Questions? Oh, okay, great.
Just hang out up here. Yeah. Just want to give you guys an opportunity. I know that as you've heard some of this, you probably have had some questions run through your mind, maybe even just explaining terminology. Want to give you an opportunity to direct questions to both Gwendolyn and Rhett, and whatever questions you may have.
Did you have a microphone for them?
And if you do, I'd like you to speak into this.
Hi, my name is Steve, and my question is, you were talking about your 18-year-old doing a will. I have a child about to turn 18 in a couple months, has no assets to speak of. How detailed, how official does this will need to be? Can she just write it up on a piece of paper, have some non-interested witnesses sign it, and that would suffice?
Yes, great question. And so an 18-year-old needs a basic plan, which is a power of attorney, a healthcare, and a will document. California Probate Code does still have a statutory will document that you can fill in. It used to be on the State Bar of California website, but they took it down. But those are the old fill-in-the-blank wills. But what we're looking for that really is just the nomination of who's going to be in charge, the executor, and then who gets whatever it is, whether it's a bicycle or a vehicle or a bank account. What happens with people not really having a whole lot is that I will tell you, a lot of times when I'm probating an estate, and there's not really a whole lot, but it's just stuff, we still want that closure. And so what happens with just having it in writing is that we have the legal authority so we can terminate that lease with the tenant or the dorm, or we can close that bank account, or we can transfer title to the vehicle. And so even though there's not a whole lot, you're making the same decisions we make with an estate plan, which is who's in charge and then who receives it. And so the question was, can she just write it out, or he or she? Can you write it out? So I will tell you, California still recognizes a holographic will, where people will go and they'll write out, this is my last will and testament, and they'll write in executor, they'll write in who gets it. California will still enforce those, but we still go through all of the critique of those wills, whether or not that person, was it in their own handwriting, whether or not they were unduly influenced. And so we definitely don't recommend them, but in a case like this one where no one's going to object, when I mentioned legal heirs and estranged heirs earlier, that's where we always have someone that might object. Unfortunately, we see it a lot in elder abuse cases where I'm married with 3 children, and so if I wrote a will saying, I really like Nash, I've known Nash for a really long time, since he was 1, actually, and I decided I'm going to just write this will to Nash, that my kids and my spouse would object to that. They would have legal standing as my legal heirs to say, we're not really sure that's what she wanted. And so here in your case, and even in mine, when I wrote that will saying my son Connor named his parents, we were the first choice California it aligned with California law. And so when someone becomes incapacitated and they don't have those documents in place, California writes one for us, and they'll look and see, oh, this child is not married, or this 18-year-old is not married, doesn't have children yet. They look first to parents, and then they look to siblings. And so my favorite example, when I went off to college, if I had had a power of attorney, I actually would not have named my parents. I have an identical twin sister. I would have named her. She was closer to me. She was in Santa Barbara, and I was in San Diego, and she would have been the better choice, first in position to make a healthcare or financial decision for me if something had happened to me. And so, yes, a simple will is sufficient, but make sure the decision of who's going to be in charge and who gets it is in there. Thank you.
Hi, Gwen. Hi. This is Kathy Winnie. I actually have a question regarding the funeral and burial instructions and then the organ donation.
Okay.
If your choice is to be cremated, can you also donate your organs? So, I mean, where they could take them out and then cremate you, or how does that work?
So you're asking the attorney how it works in the medical field. So I can't tell you exactly. Do we have any medical help? I've seen it where people do still donate organs. They'll still mark donation of organs on their healthcare directive. They'll still mark cremation, but how that looks in real life, I really don't know. But I will tell you, the only time I did have to litigate that healthcare wish, it was because the person, while she was married, chose funeral arrangements and burial, and then she went through a divorce, and then she, at her death, was being taken care of by her brother. She had no children, and she had told her brother she wanted to be cremated. And so the reason why I had to get a court order was we had to show that her most recent decision was different than what was in writing. And that could have been fixed by her just updating her healthcare directive, saying and updating everything else so that was in place. So just if you've made that decision, definitely communicate that one.
I have a question for Rhett. The RMD,
Yes.
if I have a distribution coming to me, can I dictate as to part of that going to one entity and part of it going to somewhere else? And then is it all untaxed for not my income? Excuse me. No, that was me. I'm sorry.
No, good question. So when it comes to the RMD, you don't have to gift all of your RMD. You really got a lot of flexibility. To use simple numbers, let's say you have a monthly distribution of $1,000 and you want to gift 100 or 50. You can have that $100 or $50 sent directly to it. So like Charles Schwab or Fidelity, they would write a check directly out of the IRA to the church, to the organization for that $100. And you can get the $900 sent to you. That you can break it up and sparse it however you want. It's not an all or none.
Okay. Thank you. Anybody else? Wait. Oh, come on. Nope.
They're filming it. All right. The question is really, as a former executive of an estate, there was a big argument over Aunt Susie's teacup and who got what and all that kind of stuff. When you're writing out those specific lists, is it a personal list that you keep in your documents, or do you have to file it with an attorney? And it's awful difficult to do that kind of thing because those things change over time. What's your advice on that?
Great question. So with the specific gifts, the gift to the church or the charitable giving is a great example of where you would want a gift to the church in your actual document. So my document would say a gift of $10,000 to my church, before it's distributed equally between my 3 children. And so whenever you have a dollar amount that you want to go to a certain charity or church or charity, I do recommend that's in place and in writing. Those specific gifts like the teacup, those things you can manage yourself. And so when you write that gift list, I will tell you the California standard is that you have, it's in writing. So you can't just text it to someone. You can't just email it or have it on your desktop. We don't know the passcode anyway, so please put it in writing. But so when people write those personal lists, it is personal property. When I spoke of jewelry and firearms and artwork, that really is you writing. My son is Connor, you've heard. I could write Connor, and I could write out the items I want him to receive. And it doesn't have to have a dollar amount. A lot of times people now with digital cameras are taking pictures of those items, whereas older specific gifts lists, they would have a full paragraph about the ring and the dimensions and all the things, or the artwork. But with those gifts, I do recommend that you write it out. You can type it, you just must print it, sign, and date it. So when I litigated a specific gift list, it was an Amador case here, we had 3 versions of the list, and unfortunately in her dementia, she started crossing things out and changing her mind, and no one was fighting about the list, but I have a legal obligation to protect my trustee who's a fiduciary. So the fiduciary couldn't start delivering these items that had value without knowing that everyone was going to be in agreement. And so we did a petition for instructions. We presented to the court all 3 gift lists, and we proposed what we thought she wanted at end of life. But if she had actually dated each list, or not rewrote them later, then we would have just looked at the most current list. And so those lists can be separate, maintained by you, but I, as your estate planning attorney, I like to keep a current copy of it. So if you've done that, I keep a copy in your file. I recommend you keep it with your will and trust document, because those are the items that we're going to start delivering first before we make a distribution, or we make sure that the teacup's not sold at the estate sale. We make sure it gets to the right person. But those dollar amounts, I mentioned the gift to the church, but we also see it with grandchildren, X amount to the grandchild before the rest is dispersed to children. But definitely talk with your estate planning attorney, because it always depends on your circumstances and objectives, and who your trustee is and what the size is of the estate. Thank you.
Hi, my name's Gary. We had our will and testament done about maybe 17 years ago. Not even sure if our estate attorney is alive at this point. And we have some changes as far as our beneficiaries have changed addresses and contact numbers and all that kind of stuff. Do we need to see an estate attorney to make those changes, or can that be something, a simple document that we write out and add to the paperwork?
I'm definitely going to recommend an estate attorney for you, only because when I go to court to fix things, it's because sometimes that document you write out isn't a legal amendment, or it doesn't capture everything. What I see the most with people is they'll move here to Jackson, and they've relocated from maybe the Bay Area or another city, and their new house isn't even in the trust. And so, or their beneficiary's not named on their retirement account.
Trust.
And so, what is it?
Could still be an AB trust.
It could still be an AB trust, which I will tell you, in the 1990s, trust became really popular as a tax planning tool. And so the AB trust, if you have a trust that talks about a survivor's trust or an exemption trust, and the binder is about 100 pages or it's really thick, I will tell you, we are rewriting those now to a simple trust, because if you walked into my office today without anything in place and you were below $15 million, which is how much you can give away tax-free right now in 2026, I would tell you, this is a lot of tax planning built in that you might not need. But I will tell you, there are blended families that are still using that AB structure, even if they don't have 15 million, because we use that AB structure to determine this is wife separate, this is husband separate, this is what they have together, and this is the estate plan. I will tell you, I do have some business cards and some brochures in the back, and you'll see on my brochure, I do have a review package for people like yourself that just want to pay me a flat rate to double check everything. It's $500. You bring your documents in, we scan them in, we open a file for you, and then I give you a beautiful review letter with my recommendations. And then I'm your local source for your children so that they don't have to find the attorney that has retired or the attorney who has passed away. But it's definitely recommended because you do want to know, make sure that you have all the documents that are required, make sure they actually say what you want them to say, and then we go through that double check of title to the house or bank accounts or financial accounts. So definitely something to consider.
No, I'll add to
Yeah.
your piece. So one of the things, too, promoting Gwen, when it comes to the trust work, one of the hardest things is that people say, I got to spend, sometimes it's $500, sometimes it's $5,000 or $10,000, depends on how complex the estate is. It's kind of painful, and it feels like, well, I haven't needed to use it yet, right? But the truth is, a trust might cost a $500 review, $3,000, $5,000, whatever it is. But if you went to probate and it's not set up properly, it will probably cost a matter of percentage points of your estate. And you're talking $50,000, $60,000, $70,000, depending on the size, complexity. And that's not even including the challenges of the family members and the family dynamic. The whole point of this is giving a legacy. And part of passing on a legacy is setting up your children for success. And setting up your children for success is making sure that you're doing these conversations, you're setting up your trust so that it prevents any friction. Because the thing I've seen so many times as a financial advisor is money causes people to do a lot of weird things, and people to sneak back around, or someone cares about something way more than you ever imagined. But you can avoid all that by getting the trust set up, by having the family conversations, by having the letters, and now you're blessing the family. You're making the estate much easier as the trustee and the executor, because it is a lot of work. Saving a significant amount of money, and then also that you're going to keep that family more tight-knit. So highly recommend doing it, as the rules have changed quite a bit.
Well, and I wanted to add too, I see some clients in the room. I want you to know that your review is free of charge. And so existing clients who come in for the review, you're not charged for that. And it's there in my brochure as well. I want to make sure that you're double checking things from time to time. But you call my office with a question, and that's when I catch you. Because we say, wait a minute, you haven't been in for 8 years, or you haven't been in for 11 years. So we'll catch you if you call with a question too. So thank you.
Okay, my trust is about 3 inches thick. Costs a lot, and it's 35 to 40 years old. Anyways, I have reviewed it every 5 years, but I really just I have one child. There isn't going to be anyone contesting it. I want to do a new one. My husband's passed. Is there any legal thing can I just have a new one made, or what do you recommend?
So thank you. I did see your typed question, and I'm going to see you after class.
Okay.
What it means is it depends.
It depends. It depends.
Just a quick question. I have a trust, and there's going to be no contest or anything, and it's very simple. Do I need to contact the attorney to probate it, or can I do it? I mean, can my executor handle it all?
So we kind of we just skipped over that because I just was talking to you today about just making sure you have an estate plan. And so the question now is just about who has to administer these trusts. And so I do have some additional resources on my website. So some of you have already read my articles in Ledger Dispatch, or I am on the radio still once a month. So all of that is captured on our website. And there's a great top 10 list also for executors and trustees that will give you some more information. But that question specifically, we don't need an executor until our passing. So when we talked about executors and trustees, and I said the person in charge, we're looking at what is the exact circumstance. And so the example where I said I wanted my twin sister to be my power of attorney and healthcare person, it was if I was, as a young adult, if I had had an accident or I was sick or I had become incapacitated for some reason, I wanted my sister as my financial power of attorney and my healthcare agent to be able to have legal authority to make decisions for me without a court order. Whereas if I had passed and she was the executor and beneficiary of my will, because I was before I got married and before I had children, then she would have looked to that will upon my death. And then at that point, they would have determined, do we have to probate this estate? So if I had just a bank account and a vehicle, right now in California, that does not require a court order. Right now in California, it's changed a little bit, but about 200,000 is a small estate in California right now. There's some extra exceptions. But if I just have a vehicle and a bank account, I'm not, my will doesn't have to be filed with the probate court. But if I had died with a house and it wasn't in trust, then that will would have been probated. We would have paid the filing fee. We would have paid the newspaper fee. We would have paid a percentage to make sure my sister got court appointed as my executor upon my death. And then also we received a distribution of those assets in her name upon my death. A trustee works upon your incapacity or your death. So in your case, if you're co-trustees and co-beneficiaries of your current trust, it's a living trust, you're still living. If you become incapacitated, your co-trustee can be a sole trustee. And then if it's when you're both gone, that's where we look at your trust to see who is the successor trustee when you're no longer living to gather assets, pay debts, and divide what's left over. So right now, you are your own trustee. Your house is in trust, your bank account is in trust, but you're signing on behalf of the trust. You're still the owner. You could sell that house today or refinance that house today, or you could take money out of your bank account. You are the trustee right now.
But I don't have, so if I pass, I don't have to, my executor doesn't have to go to the attorney. If it's, she can expedite the whole thing, right? She doesn't have to have an attorney.
She doesn't have to. I will tell you, in my office with co-trustees, I do a surviving spouse meeting, always with my surviving spouse in my office, and you'll see it on my brochure. That's a complimentary service because we want to update the trust as quickly as we can because there's a certification document that is now void or invalid because the original one said husband and wife are co-trustees and co-beneficiaries, and now that you've passed, then your surviving spouse is the sole trustee and sole beneficiary, but there's not always administration. The AB trust that we were talking about where there's some tax planning involved, the surviving spouse does have some work to do. She's going to have to meet with the financial advisor. She's going to have to get some tax advice. And so the attorney phone call is recommended depending on, and then let the attorney decide what needs to happen next. But we don't plan on anyone getting court appointed or there being a fight yet or anything like that, but we still want to help that surviving trustee.
Okay. I don't have a surviving trustee anyway, so
Oh, okay. So are you the surviving trustee right now?
yes.
Okay. And so that's where it depends. I'd have to look at your documents to determine, are there legal notices that have to be made? Are there legal heirs or other beneficiaries? Okay.
No, it's pretty clean. It's pretty
Okay.
clean. And the reason I asked is I have been executors for a couple of deaths, and we never went to the attorney because they were so clean. And I just was wondering if you had to go see an attorney.
You don't have to see an attorney. What I will tell you, if you get everything done correctly, everything is in trust or everything has a named beneficiary and there is no fighting, then there are some estates that can be administered without an attorney. But a lot of times we still have to give legal notice to legal errors that might not be included, or we just have to make sure everything's been wrapped up and closed down. But you are correct, from time to, and I celebrate it. When I have a client come in and say, I was the executor and everything went fine, I celebrate that. I'm glad when things go well, because that's the
Just want to make sure I
plan.
was in the right.
Yes, that's the plan. We want things to go smoothly, but it does take some planning, some legacy planning on your part to make sure that those documents are in place and that everything will go smoothly.
Sure, thank you.
Thank you.
On a little different subject for you, young man.
There we go. It's your turn.
On a required minimum, whatever it is, RMD, whatever, that you're taking your money out of your stock portfolio because we're old and we have to pay the piper, I guess. But anyway, the disbursement of that, is that done once a year, once a month, once every 6 months? In other words, can you set that up at a schedule, or how does that work?
Yeah, so I'll just explain an RMD in general. After you're a certain age, what is it, 72 and a half now, 75, 73 now. They've changed it 3 times in like 3 years. At 73. So after 73, you have to pull out a certain amount of money because the tax man wants his dollars. And you calculate that using the 12/31, December 31 value of that account every year. I'm going to use simple numbers. Let's just say they say it's $20,000 is your required minimum distribution. That means in 2026, you have to pull $20,000 out of that account. It could be done in any way you want. You don't have to do it just one time. It can be done monthly, quarterly, annually. Just need to have $20,000 out of the account in the calendar year. And then whether you're using that for personal use, charitable use, does not matter.
If it's to an institution like this church, do you have the money sent directly?
Yes. Directly to the church. Yeah, so you want to make sure that you tell that institution, I would like a check sent to this church, here's the address, and they will send it directly out. Because if the money hits your bank account, you're going to be taxed. It's going to show, because there's going to be a 1099-R is what it's called, and it's going to reflect that you received that money, where if you send it directly to the church or you have the institution send it to the church, it won't reflect on that 1099-R. Say again? Yes.
Would you repeat the question?
He asked if you need the church tax ID.
Oh, okay.
Sometimes. It depends on the institution. Generally they want to know the institution and the tax ID because they need to verify that it is a 501c. So that's really the key.
And charities will share that information.
Yes. Charities share that information.
It's sometimes on their website.
Yeah, often there's also, you can look it up online. It's fairly public source information because people need to know whether it actually qualifies. Yeah, good question.
Other questions? Oh, I'm sorry. I thought you were waving at me.
I was waving at you. Actually, probably for Gwen. I have an unusual situation, so I'm wondering if my mom needs a will. So here she is, 88. She's living with me. She has no assets, no car. She has a couple bank accounts, and they're in joint tenancy. Does she need a will?
So in that example, the accounts were joint, and so if you have someone on your account, it's survivor takes all, so that money won't be frozen. The survivor can take that money. But I, as a estate planner, have to ask the question, what if something happens to both of you? And so then the next step would be to make sure that there's a pay on death beneficiary. So if the two that are on the account, something happens to both of them, we've got a pay on death or that beneficiary form filled out. And so here, that would qualify in California as a small estate. And so here, upon her passing, you would close the account as a joint owner. You would just take her personal items, and you wouldn't have to get a court order. You wouldn't have to give legal notices. But again, it's always. right? It's my daughter, Kate. What we have to do is, it's always, so in that case, that would be an example where we don't anticipate anything. But I will tell you, and I'll use Butte Fire as an example, sometimes people think they have it right. We had a case where the house burned in the Butte fire, and the decedent settled the case and was supposed to get her check from PG&E and didn't cash it before she died. So we had to open a probate estate, and there was a big fight because the daughter that was on title to the property was not the only heir. There were children from a previous marriage that came forward, and I can share this with you because it's court record. Since she didn't have a will that said all goes to this one daughter, the bank account was joint, the house was joint, but the proceeds were in her name only, and that settlement was her name only. So had she had a will that reflected all to this one daughter, not the 5 kids from a previous marriage, then that settlement check wouldn't have been litigated. And so here we don't anticipate anything like that happening for her. So it sounds like she has the probate proof case, but just make sure she has a power of attorney and health care while she's here in California.
Yeah, and then the pay on death, go to the institution and ask for that form specifically. So like, what's the institution? What's the bank? Go to Wells Fargo, and you and your mom directly say, hey, can we get a pay on death form? And they'll give you that form to do.
Thanks.
Other questions? Well, I would personally like to thank you two for coming. This has been very, very informational, very helpful in my own mind. So I'm sure that if you have some questions for these two, they'll be hanging around for a couple minutes. Make sure that you stop by Gwen's table in the back, and there's some refreshments over here still. So thank you for coming.
Thank you.